Justice Gorsuch?
We haven't had a chance to discuss 1252 much, and I'd like your thoughts on that. And in particular, if we were to agree with you on that, do we have to address your standing arguments, let alone the merits?
No, I think that if the court agreed with us on the scope of 1252F1 as prohibiting the vacatur that was ordered here, the court could say that alone and stop. That's also a jurisdictional threshold issue in this case.
Is it jurisdictional, though? We've had some question about that last term, as you'll recall as well, and whether it's just a remedial limitation on remedial options for the district court or whether it is truly a jurisdictional statute.
So we think that it is clearly a jurisdictional obstacle to entering a form of relief, and Congress is free to attach the jurisdictional label and the jurisdictional consequences to provisions like this one, which take particular remedies off the table. And 1252F1 itself says that courts shall not have jurisdiction to issue these kinds of orders that enjoin or restrain. So we think that it does clearly function as a jurisdictional limit.
Okay, and your friend on the other side has made certain arguments about why 1252 doesn't apply, and I just want to give you a chance to address those.
So we think that their arguments are fundamentally inconsistent with both the text and the purpose of the statute. Their argument seems to be that the word restrain in the statute does no work at all, that enjoin and restrain is just superfluous. Congress didn't need to use that term, but we think that that clearly ignores the fact that the court generally doesn't interpret statutory language to produce that kind of superfluity. And then there's a second statutory principle here where the very next subsection of F2, 1252F2, uses just the term enjoin. And that implicates the principles this court has articulated that Congress generally means different things when it uses different language in adjacent subsections of the same provision. And then on top of all of that, we think that Texas's arguments would essentially create a giant loophole in what Congress was attempting to do with this statute. The whole point of this provision is to prevent lower courts, not this court, but lower courts from entering coercive programmatic relief while the case is being litigated, and that's precisely the effect of universal vacatur here.
You indicated earlier, I believe, that you thought a district court could still enter a declaratory judgment, and at least my recollection is the federal government tries to abide by declarations of the law. So how does that fit into your theory?
So I think a declaratory judgment would not have been coercive in the same way. If the district court had entered a declaratory judgment here, it wouldn't have required us to comply. We would have thought that that judgment was entered in error. We would have pursued our appeal rights, and I think that DHS would have been free to continue to apply the guidelines in the interim while the case was proceeding.
Okay, and on the APA argument, some of us didn't have the benefit of sitting on the D.C. circuit 5 times before breakfast entering these orders, and you know, I stare at the language and I hear your argument. I think your friend on the other side is going to point us most specifically to the language set aside in 706 and hang his hat there if I had to guess. And I'd just like to hear your response.
So we have never disputed that set aside can sometimes mean vacate, but I think it's equally clear that that text can sometimes bear the meaning of disregard or literally set to the side. That's how the court uses it when it reviews federal statutes, for example. If the court thinks a statute is invalid, it might say, we're setting aside the statute.
We don't erase them from the books.
Correct. You do not vacate or void the statute and take it off the statute books. Instead, you literally disregard it for purposes of fixing the rights of the parties before you. And we think that's how Section 706 uses the term. The reason for that is because 706 is setting forth a rule of decision that governs across all of the cases where APA claims can be brought, including things like habeas actions or judicial enforcement or judicial review of an agency enforcement actions. And there it would be just like a statute. You can't vacate an agency regulation in a habeas case. You would have to set it to the side. It's Section 703 that sets forth the remedies under the APA, not 706. And we think that if you look at the context here and also the history, that there was no intent by Congress to create a truly unprecedented, sweeping, non-party specific remedy, it fortifies the conclusion that that would not be the proper interpretation of the text.
I mean, it is kind of interesting that remedies are expressly listed in 703, that Congress would sneak in the most important remedy and by far the most sweeping one in Section 706, what is it, 2B? Something like that. Which governs the scope of review, and that nobody at the time, Davis, Jaffe, people who noticed things, noticed this innovation.
That's correct. We think that certainly if Congress were going to take the action of creating this kind of unprecedented remedy that operates directly on the agency rule itself rather than with respect to the parties, someone would have said something and Congress would have made that much clearer in the text of the statute and not separately addressed remedies in 703.